Legal advocacy and access to justice is one of our fastest growing programs. It's something that we get a lot of questions about. Sometimes our clients can be a little hesitant to reach out for legal services. Either they think, I can't afford it, I don't know that there are services that would actually provide, what I need at the price point that's needed, or they've been disillusioned with the system, whatever that looks like, law enforcement, the legal system, which can be really challenging. So we really appreciate the partnership between our agency and both of your agencies. It's really important to have our clients understand, and we want them to continue reaching out for legal services so they can get the best response for their case. What you guys do is so needed. We get so many questions about it. We want to remind our viewers that this is not legal advice. If you have questions, we want you to consult an attorney. Please reach out to us if you need help connecting with one. Thank you both for being here.
Thanks for having me. My name is Lisa Russell. I am a staff attorney over at Charleston Legal Access. I handle our partnership with My Sister's House. I do predominantly family law, domestic violence law, orders of protection, as well as guardian ad litem work. I do a lot of the safety planning and legal consultations for the My Sister's House clients, as well as full representation.
Great. Thanks, Lisa. Scott.
Thank you for having me. Also, Tosha. Scott McNeish. I'm an attorney with South Carolina Legal Services. We're a statewide law firm, and we handle a number of civil matters. I'm the family law unit head, so predominantly I do practice family law. I do orders of protection, as well as divorces based on physical cruelty, adultery, any number, and dealing with child support, custody cases, alimony, you name the issue in the family court. I'm generally doing.
So a lot of questions, because these are complicated issues, particularly when you're in trauma, right? You're not always processing or remembering everything that our court advocate, Cheyenne Beats, may tell you in court, or that other legal service providers are giving you. So we're excited to have this opportunity to have these discussions. We're going to start off with orders of protection. Can you explain the difference for our viewers between an order of protection and a restraining order?
Absolutely. So the first fundamental thing is you're going to get an order of protection from the family court, and you're going to get a restraining order from the magistrate's court. So your starting point is going to be in a different location for each one, and they have different what's called qualifying behaviors or qualifying actions. So the abuser's behavior and the actions that have to actually be done are going to be different, and then that determines whether or not you're going to go the order of protection route or somebody would be going a restraining order route.
So when a victim may be thinking about which route to go, is this something that you would suggest the victim determines which route to go, or do they really need to come to an attorney to discuss this?
I think that they should come to an attorney to discuss it because they may have some overlapping behaviors. And so when you're thinking about restraining orders, you're going to fall under an umbrella of what the law calls harassment or stalking, right? And some of those behaviors you may see in order of protections and in the qualifying behaviors for order of protections, depending on how far each of them go. And so really it's going to be a factual decision based off of what immediate needs the victim may have, if there's additional family law issues where an order of protection may be able to address custody, temporary child support, those kinds of things, whereas a restraining order doesn't have as much flexibility. And so you want to make sure that you're sending the victim to the place that's going to be able to address the most of their needs, especially really when you get into families and there's other things that the order of protection may be able to address for them. So it really depends.
I'm glad that you bring that point up because I don't know that a lot of our clients or a lot of people in general realize there are other things you can ask for in the order of protection. So thanks for clarifying that. Scott, what is an order of protection and how would I qualify for one?
Well, an order of protection is in essence a restraining order, which is going to restrain the respondent in the case from certain behaviors. Generally, they're going to be communicating, continuing the abuse with a person or coming about their home or place of employment. Like Lisa indicated, there is additional relief that's available to them in a family court. The difference, not the difference, but the issue is, are they household members? So to qualify initially to be in the family court, you have to be able to establish that you're a household member, and that's defined by statute. So spouses, former spouses, people that have children together, or people who formerly cohabitated together are considered household members. So if you don't meet that criteria, you will not be able to advance a case in the family court for order of protection.
So if you're a dating partner and you don't qualify under that statute, is the restraining order the only sort of approach that you have available?
Well, it depends, and you don't have that in the family court. So if you do go to the magistrate's court, but as Lisa indicated, it's slightly different relief, and the qualifying factors was their stalking and harassment. And that's the relief available in the magistrate's court for restraining order. It's limited to stalking and harassment. So they are dissimilar in that way, which is again why if you speak to an attorney, but you may have other relief available to you, but again, it does depend. So much of this is factual, so it's always going to depend on the situation. Are there children involved? That may move you back into the family court, but under another action, perhaps not necessarily in order of protection. So it will always be a case-by-case determination.
If I am hiding from my abuser and then the abuse starts up again, if I file an order of protection, am I essentially giving that person the location? Like, this is where I am, come find me. Does that put me in more harm sometimes to apply for an order of protection? Or is that always going to be generally the best case for me?
Just so I understand, maybe so that I'm understanding the question is the question if I'm filing for the order of protection, does that in and of itself put me in any additional harm?
Yes.
Perhaps. Unfortunately, one has to have notice that an action is being brought before them in court. So there's not a circumstances in which an order of protection can be issued without the other side being served notice of the proceedings. Now, part and parcel with the notice does not mean that they are provided your address or where you necessarily live, but they will be made aware of the action in the county in which it takes place.
And how do you file for an order of protection?
It's a filing of a petition with the court. It's a form that's available through SC courts. You can get them at the courthouse. If you wish to file these on your own, again, we recommend that you speak to an attorney always prior to make sure you're making the correct selection as to what venue, what court you wish to use. But it's starting by the filing of that petition, which will ultimately be served on the respondent or the abuser in this case.
And then generally, how long do you have to wait for that order of protection to be granted?
Well, it depends. So emergency relief is available. So if the facts are sufficient and warrant as much, the court can issue that a hearing be held within 24 hours of service. So that can be scheduled within 24 hours to 48 hours of its filing, provided, and what we heard, provided it's been served and the other side has notice. So long as they've been served prior to the hearing, then notice will be sufficient. If it does not qualify in the court's eyes as an emergency, it'll be scheduled within 15 days of the date of filing. And the other side will have to be served 5 days prior to that hearing date.
And if you are interested or you think you might qualify for an emergency order of protection, what are the stipulations there that you have to meet?
Basically immediate harm. That would essentially be the standard. The court wants you to demonstrate through an affidavit, which is filed along with that petition, that there is some immediate harm, either to yourself or to somebody else in the household, who may also be on the petition. You can file that for other household members that are minors.
Thank you. We're gonna go to restraining orders. Lisa, how do I qualify for a restraining order, and how do I file for one of those?
It's a very similar process. The forms are available to the public through South Carolina Court Forms. It's free to file up front. There may be some fees on the back end, but it's free to file up front. And so you're gonna go back to that factual determination of, am I in the right place and do I qualify for it? So the good thing about a restraining order is when you have the qualifying relationships for the order of protection, you don't have those in magistrate's court. So anybody who's experiencing the harassment or the stalking can request relief from the magistrate's court so long as they can show that the stalking or the harassment is happening. And so you're looking at two different levels of harassment. And so for first degree harassment, you're looking at the physical behaviors. And I think that's the best way to quantify it, at least in my mind, is we've got harassment one, which is gonna be following somebody from place to place, physical intrusions, repeated intrusions of, following is always the best way to think about it. Showing up at somebody's work, breaking into houses, property, right? In this kind of situation, I'll often see screens ripped out of windows, holes in the wall, those kinds of things. And then harassment two, you're gonna get into the repetitive communications, right? Unwanted emails, text messages, phone calls, letters, and unwanted intrusive communication, right? And then you're gonna get into your last piece of stalking, which has defined by statute very specific things it's gonna look for. And the key ingredient that you have to be able to show is that there has to be a pattern of any of those behaviors. And a pattern is going to be 2 or more instances of the intrusive behavior that don't serve a legitimate purpose, right? And so you have to be able to show that this has happened more than one time, that you've communicated that this is unwanted. Sometimes you can do that through a police report, or I've seen text messages that just say, I don't want you contacting me, stop calling me, and making sure that the other person is aware that it's unwanted. And again, it can't serve a legitimate purpose, right? So those are gonna be the things that are gonna get you into magistrate's court on the stalking and harassment piece of it.
When you guys talk about having to report multiple incidences, right, like 2 or more, is there a time frame in which that has to happen? Does it matter if it's within 3 months or a year? What is that time frame? What's it look like?
That is a great question. They don't have to be within a certain amount of time frame, but they have to be connected, right? So you have to be able to show that they're related to each other, either by same type of behavior, either same type of person, same cause, same types of emails, letters, intrusive behaviors that are unwanted. So they don't have to be back to back. They don't have to be, within the same week of each other. I would say the closer they are together, the stronger that argument is, and the stronger you can build that case, which is why documentation of the unwanted behavior is so important. But there is technically no time limit on how close or how far away those instances have to be.
I think the question comes down to, does it qualify as a pattern? And I think the further the instances are, I think it may be more difficult to demonstrate a pattern in front of a judge.
If somebody is stalking me and maybe they're not breaking into my home or coming inside of the place where I work, but they're following me around, how do I document that?
So the best way to document those kinds of things is to have corroborating witnesses, right? So talk to people about it. Have somebody come get you if you think you're being watched, so that you have another person saying that they were there and they witnessed it and they have personal knowledge of it, and that they're able to say, I went, using myself, I went and picked Lisa up at her job and, so-and-so was there in the parking lot. And I went and picked her up from the movies and so-and-so was there in the parking lot, right? Or they've shared this with me, we've had this conversation about it. And having those corroborating witnesses just continues to build the pattern, right? And that's one of the best ways to, show that there's something going on, is having somebody to back that up.
I see how that could also play a part in our safety planning, right? Whether they're talking with an advocate from my sister's house or one of you, how those things are really important. What about the time frame around receiving a restraining order? Is it similar to an order of protection?
Yes, it's almost the exact same timeline actually. So you can have emergency ones that would be within 24 hours of service. And I believe it would also be within the 15 days. And the same service timeline as well, that if it's an extended one, the abuser or the respondent has to be aware by no later than 5 days beforehand. So they have to be served by, usually my rule of thumb is a week, to give everybody some safety.
there are rules regarding how you count time under the law. And again, an attorney can help you make sure that the service is being effectuated within the time frame to ensure that your case is going to go forward. I do think it's worth noting with the restraining orders, under that statute, an emergency restraining order can be issued prior to a hearing being held. In other words, if you submit your affidavit and the court determines that the danger is immediate, and a restraining order can be issued at that time, and then the matters will be taken up before the court. So at the next hearing date, it may not be granted, it will depend, it's a case by case, but until such time as it's heard, the emergency order can be issued. That's something not available through the family court that's unique to restraining orders under the stalking and harassment statutes.
Is there one that sort of supersedes the other if I'm, considering a restraining order or an order of protection?
Not necessarily, no. So you can qualify for more than one. There can be more than one. I don't know if you necessarily need more than one. I think it's really a factual determination based off of what is the necessary relief and what is going to be the best route for that individual to get what they need and what their protections are.
Once I am granted an order of protection or a restraining order, am I physically given a document to bring with me to show to law enforcement or advocates or other victim service providers? What sort of documentation do you receive?
Yes, you will receive a written order. Like in the case of an order of protection, it is again a form order. It will be provided under the order to a respective sheriff's office or multiple sheriff's offices, definitely the one in which the county. If there are limitations on the ownership of weapons during its time, law enforcement would be made aware of that. Guns may have to be collected. So, and then yes, you will have a copy, the respondent will have a copy so that you can have it on you at all times in the event that there's an issue with a violation of the order.
And what happens if I accidentally lose my order of protection? I lose that document. I'm moving, I have to leave my home suddenly. Where would I go to get another copy of that document?
You would be able to request another copy from the clerk's office that heard the petition, right? So if you filed in Charleston County, you can go back to the Charleston County Clerk's office and request another copy or request additional copies. I always recommend that if there's any minors, for example, covered under the order of protection, that you have additional copies just in case somebody may need one. For example, the school, daycare, those kinds of things, if it has stayaways in it, those are always helpful to have extra copies of.
And if I am a client of my sister's house and I'm currently working with the court advocate or a therapist or another advocate within the agency, how do those individuals work with each of their respective agencies?
So, for example, the court advocate here at my sister's house will usually send me an email. She's got, permission to provide me with her contact information. She'll give me a little bit of an overview about what's going on. And then we can either navigate that situation together. I always do warn though that once you involve other people in conversations with attorneys, those conversations aren't protected anymore. So there's always kind of a warning there of bringing everybody into conversations with your attorney if you do have one. However, I like to work in tandem, right? Because I do believe that advocates provide a support that attorneys can't. Sometimes an attorney has to have a very hard conversation with a client, and it's not always going to be a happy conversation. And so I feel like I personally really try to work with the social worker or the advocate because I feel like they fill a gap sometimes that I can't fill because of my obligation to give you your options.
It's really the only way to do it. We really do serve different roles. We're not licensed clinicians. We're not licensed social workers. We're not licensed clinical therapists. We're not, nor did you come to an attorney for that role.
If there is one thing that you would like our clients to know, or any potential victims who are watching, any sort of important last messages or things to keep in mind?
Of course, I would say this as an attorney, talk to an attorney before you make a decision as to go into court and represent yourself. At the least, make an informed decision. You may ultimately decide not to retain counsel. You may ultimately decide to do it on your own, but at least it'll be an informed decision.
I always say that, the first step to deciding which option to take is knowing all of your options and that's where we come in. We're the professional problem solvers. We will give you your options.
So if I call and I'm looking for services, what sort of procedure should I expect is gonna follow?
With South Carolina Legal Services, you can call the individual offices, like with my sister's house. Say we work with you guys, where we'll get a direct referral oftentimes. If you were calling in, you can go through South Carolina Legal Services .org, and you can apply online with us, or we have an 888 number one can call. I will say that 888 number does service 9 offices, 3 statewide organizations, so you may have to try a couple times. But an intake will be done, it will be directed to the office in the county in which it services the county in which you need assistance, and that will be given to an attorney. You'll speak to an attorney.
Charleston Legal Access, it's very similar. You can go to our website and complete the online intake form, and that will be sent to our intake manager, who then completes the first round of intake information. They will get your demographic information, contact information, and general overview of the situation. If we receive a direct referral from my sister's house, usually that will go direct to me, and then I will either direct it to a more appropriate legal service, or I will direct it to our intake manager and start that on our end. Once that has been completed, you will end up assigned to a staff attorney who will handle the legal part of the intake process. If any advice and counsel is warranted, give you a call, kind of talk to you about your options. However, we are not a statewide organization, so we do only serve the Tri-County area, so we only cover Berkeley, Dorchester, and Charleston.
My sister's house is really appreciative of the partnership that we have had and continue to have with both of your agencies. We can't do this work alone, so it's really nice to be able to have really well-qualified, I think trauma-informed attorneys who understand what our clients are going through, to be able to advocate. Education is so important. Certainly around what our victims are experiencing, what our clients are going through, and then being able to have attorneys who also understand what that cycle looks like, so you can explain it to other attorneys, so you can advocate the best way that you can in court for our clients. Thank you so much for the continued partnership. We look forward to seeing how we can expand our Access to Justice program in conjunction with Charleston Legal Access and South Carolina Legal Services. Thank you both so much for being here, Lisa and Scott. A wealth of information. We always appreciate you. And on behalf of our clients and our staff and our court, thank you so much.